Hi, good evening. My name is August Bournique, and I'm going to talk about the Cyber Resilience Act. So let's see how this works. Oh, it goes the other way. Big green one. Oh, yeah, that makes sense. So obviously, I am not particularly technical. I'm an attorney who is California licensed, working out of Amsterdam. So of course, we have to start with a disclaimer. And that disclaimer is that this presentation is general information. I'm not giving you legal advice, and I'm not your lawyer because I don't know what your specific situation is. So, the Cyber Resilience Act. It's an EU-wide digital products regulation that is brand new. And it has some friends. And I'm not going to talk about these other ones. You might hear about them in the same kind of conversations. But the main one here is the CRA. So what is the CRA? So, as I said, EU-wide product regulation. Every digital product in the EU will theoretically be covered if it has a network component. And there's a few exceptions, but they're already highly regulated. So the point of it is to ensure that manufacturers of digital products, those products are secure throughout the life cycle of the product, and that consumers will have more knowledge about how secure their products are. Also to sort of harmonize regulation, product regulation throughout the union. You may have heard about this before because it goes back to 2022, but only now in 2024 has it been adopted, which means that 21 months after adoption, it's going to come into play. It's going to be active, at least some of it. 3 years after enforcement, so October 31st, 2027, the full array of regulations will come into effect. So what are those regulations? And why might this be a problem? Because it sounds like you have a lot of time. So first of all, it's a product regulation. So your development time on a product might be more than 2 or 3 years. So maybe start thinking about it now if that's the case. How will it regulate? First, that 2026 requirement is going to be reporting. Manufacturers need to report breaches, vulnerabilities they know are being exploited, and they're going to need to report them both to ANISA and the local CSIRT, and that's the union-wide information security agency as well as the national response team. It's going to be a bit of a process, but it should be fairly simple, fairly straightforward, even if it takes a while with follow-up reports. But then in 2027, you start getting to standard certification. And that is going to be a lot of work because it's going to have technical documentation of your whole compliance process and throughout the product lifecycle, ultimately ending up in sort of a consumer mark system for digital products or network-enabled products, because this also covers things like, Internet of Things stuff. And it's all backed, of course, by fines and penalties. But let's also look at some of the unstated realities of laws in general and the CRA in specifics. The goal here isn't necessarily to watch and see what everyone is doing, but rather to be seen to be acting on security breaches, and to force, obviously, manufacturers to start caring about product safety and consumer privacy without doing too much harm. So the problem I see here as an attorney litigator, formerly, is that this is a vast regulatory scope. Every product in the EU with a network connection, and that the primary regulator only has about 100 employees. So that's a lot of work for those people. So what instead the CRA relies on is self-assessment and certification. And self-regulation can be useful, it can be good, it can work really well, but not always. It's not always that well followed. And I think that's going to be a hurdle for the CRA. But what I really want to talk about, now that I've used up most of my time, is will the CRA apply to, let's say, my open source project? And the answer, officially, under the CRA, is probably not. But, as with all these things, as a lawyer, I have to say, it depends. So, first of all, we have to look at the definition of FOSS under the CRA, and that's software that has a publicly available code that is offered under an open license. In that case, theoretically, the CRA shouldn't apply to you unless you're commercial. Well, what does commercial mean? We'll get to that in a second. But first, the first question you should be asking is, would it apply to me anyways? The first protection is, my project isn't a product. It's not a physical good. It's not software, or it doesn't have a networking component. And a lot of things aren't products that people do in the open source space. You know, contributing to someone else's project, it's not a product. You're not a manufacturer. Similarly, software as a service even, while it's regulated under other laws, is not regulated under the CRA. So ISP, IXP, you're safe. You don't really need to care, probably, so far. Hosting, etc. So your protection B is, am I a commercial open source project? We don't know what this means exactly, because open source has been talking with the regulators, and they haven't really gotten a clear answer, but we do know what it's not. We know that it doesn't just mean receiving some donations. We know that it doesn't just mean having a contract or two for maintenance or even for new features being added. So it's something more than just getting some money. And then, of course, there's the question, what if someone uses your project commercially? The CRA doesn't apply to FOSS that's included into another commercial product unless it itself is commercial. So the manufacturer of a commercial product uses a FOSS project, they have to make sure that the whole thing meets CRA's requirements, unless it was sold to them with commercial intent. You make a FOSS product to include in other people's things, you've got to follow the law. So even if your project's commercial, there's still protections, because I haven't gotten into all the details of the CRA, but it has multiple levels of regulation. And the most standard level is the general product, allowing self-assessment. And no matter what project you're doing, if it's open source, it will be considered a general product for the purpose of assessment, which makes it much easier. And you know, honestly, if it's commercial, you can afford a lawyer, which is probably the other important thing here. But there are even protections after that. First, you know, if you're a small business in the EU, a micro enterprise, that is pretty big. There are much lower fine requirements. So you look at that fine, it's like 15 million euros or something like that. That's scary, but if you don't have that money, you probably aren't going to be fined that much. And then, of course, there's this concept of open source software stewards, which is amazing and interesting, and we don't have time for it, but basically NGOs that will be looking at FOSS projects or involved in FOSS projects, like Linux Foundation. And they'll work with regulators to create a set of standards. So if you're working in that domain, there may be a set of standards that you have to follow that's much easier to follow. So again, the text versus reality here thing comes into play. The legal code that is involved here is not it's not self-enforcing. It's not a black box. So whatever it says there is going to be interpreted over time, and ultimately probably without absurd results. So basically what I want people to get out of this is that, is an OS project going to be the regulatory target? And think about, does it even apply to me? So, mostly the things you need to be concerned primarily are you making money? Are you collecting private data that you're then selling and making money off of? And are you a tempting target for someone to steal all that data and put it out there and annoy the regulators? If not, you're probably okay. If so, hopefully you can afford an attorney. You probably should be able to. And then, just watch out for what happens with this. So I only have 30 seconds left, so very quick question. And this is just some resources if you want more information. My website, the current act, and the ANISA standards that will be used to actually implement the CRA.